our introductory speaker, Chiara Giorgetti, Professor Chiara Giorgetti. I would like to give special thanks to everyone here. And at some stage, this Thanksgiving, I learned about an application called Get Real, and basically it shows what's on backstage. And what I can tell you is that on backstage here, there's a few people, and we're delighted. We really are delighted to being hosted by Alan Overy. Alan Overy and Patrick Pearsall and Gaila Gehring Flores and many of the attorneys here have been strong supporters of Washington Arbitration Week. The pandemic did bring many things. One, the ability to launch the first edition of Washington Arbitration Week. We had at the time more than 2,000 people joining us online. And the second edition, we did a small transition into hybrid. And this year, when we start knocking at our very generous hosts, thinking that we would have perhaps about 6 or 7 in-person events, everyone started to raise their hands and saying, no, we do want to have in-person meetings. So as a result, I would say that between 90 and 95% of Washington Arbitration Week is taking place in person. I see amongst the audience friends who are not only a part of the DC, strictly speaking community, but they're part of the extended international arbitration community in the world that comes to DC very often. People from Spain, we have heard about people from China coming in. So this is to grow. With that, I would say simply that we're tremendously thankful to all of our sponsors. We're tremendously thankful to all of our moderators. I cannot name all of them, but let me start by thanking Chiara, who has been also a supporter of Washington Arbitration Week, especially on one topic, which is the code of conduct. We have had in the past many panels on the subject, and we thought, well, should we have another panel on the subject, or should we simply have something of a special event? And since she is a Washingtonian, and since she has been here for many years, we thought, well, what a great possibility to have her as the introductory speaker. But before giving her the floor, and despite her potential embarrassment, I will say that Chiara Giorgetti is a professor of law at Richmond Law School, and she is immediate past chair of ITA's Academic Council, vice president of the American branch of the International Law Association, and elected member of the American Law Institute. She's also currently a senior fellow at Columbia's Law School International Claims and Reparation Project, where she advises Ukraine on international claims and reparations ensuing from Russia's aggression. Presently, she's many things, but presently, and for our purposes, she researches on, yes, the Claims Commission, as well as ethics, the drafting of the Code of Conduct of Ethics for arbitrators and issues of state responsibility. And prior to joining academia, she worked extensively with the United Nations in New York and Somalia, and practiced international arbitration in White case. She has degrees from Yale, Bologna, and London School of Economics. So only that. And she also did a year of extensive fellowship at ICSID, where she started drafting the code of conduct that is just about to be finalized. And she might have some news hot out of the oven in her introductory speech. So with us, Chiara, it's a pleasure to have you.
Thank you very much, Jose Antonio, and thank you for having me today as the introductory speaker on the Code of Conduct. It's really a pleasure to be in person and online at the same time. Really, what has become a very vibrant week, and I understand the the most attended arbitration week in the world. So congratulations, the program this year is fantastic, including a keynote speaker by Secretary General of ICSID, Matt Kinnear. So thank you for inviting me to be the introductory speaker, and very much looking forward to the entire week. So as you said, Jose Antonio, I have been working on the code of conduct really from its inception and even before, because I was always very interested in issues of ethics. And I'm glad today to be able to talk a little bit about what's going on, because a lot has been agreed upon, but there's still some issues that need to be finalized. And I would think that the draft code of conduct is really one of the most promising reform proposals that are being discussed in working group 3 of ANSI. In a short period of time has already gained substantial interest and support among stakeholders. So in the time that I have today, I would like to do 3 things. One is to put the code in context, to give you a little bit of background in the context of the larger reform, explain what is in the code now and what is still remaining to be agreed upon. So the first question, what is in the code and the code in context? Sometimes we say that the code of conduct is a low-hanging fruit in the ISDS reform. And is it true, or where do we stay? As we know, ISDS, investment state dispute settlement, is undergoing a profound process of reform. It's catalyzed by a complex and multi-faced backlash to perceived anomalies in ISDS itself, including how adjudicators are appointed and a perceived pro-investor imbalance in the system, as well as a general concern of the correctness and consistency of ISDS decisions. And the process of ISDS reform is mostly now taking place in Working Group 3 of ANSI, where state delegates are discussing issues big and small, really systemic changes, for example, creating an investment court, and smaller one, maybe possibility of including possibly counterclaims or more direct changes. And the Code of Conduct is a key reform that would address both systemic and the specific concern. As we know, ISDS, investment state dispute settlement, is a very complex dispute resolution mechanism that involves parties and counsel and adjudicators from very diverse jurisdictions that are admitted to practice of law under diverse rules and who have undertaken different legal training and education. And by introducing common rules of behavior, a code of conduct for adjudicators in ISDS would help address these issues and reduce complexity. And in fact, it's also quite surprising that we don't have a common code of conduct yet. We have, in fact, many new code of conduct that have been approved more recently. For example, a lot of international courts have code of conduct. The International Criminal Tribunals for Rwanda, former Yugoslavia, the International Criminal Court, all have code of conduct for adjudicators. And the several international arbitral institutions also include code of conduct, like the Code of Ethical Conduct for Hong Kong International Arbitration Center. And some BITs now also include code of conduct and ethical rules. So the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, the CPTPP, for example, or CETA. So the reform project that we are seeing now is something that is innovative, but it's also in the context of a larger project that include ethics in our work. What is new, however, this is a multilateral codification that can potentially apply to all ISDS cases, regardless of the arbitral institution. It involves 2 of the major international organizations that work in this space, ANSI and ICSID. How did we arrive at working on this code itself? This was prompted by a proposal by Algeria in 2015 and received by then the ANSI Commission. And with approval, the ANSI Commission then in October 2019 suggested that the secretariats of ICSID and ANSI cooperate in preparing model provisions for a code of conduct for adjudicators. And this is really quite unique, because it's quite unique to have ANSI and ICSID working together to create a code of conduct. For this purpose, Working Group 3 has been tasked to prepare and to work on this code, and highlighted several issues for possible inclusion in the code, including adjudicators' independence and impartiality, integrity, diligence, and efficiency, principles related to confidentiality and competence, and obligations related to disclosures. Working Group 3 also requested the secretariats to study ways of addressing very specific issues, including the issue of double hatting, issue conflict, and repeat appointments. And all these issues are now addressed in the code. The first draft of this common effort of the code was publicly made available on the website of the secretariats together in May 2020, and a lot has occurred since. A second draft followed in April 21, and the secretariats organized a series of dissemination events to explain the content of the code and gather further comments. A third version was published in September 2021, a fourth in July 2022, and I hear that the fifth is really imminent. The first reading of the draft code occurred then in November 21, and then the second part in February 22, together with numbers of informal meetings and intersessional meetings. And I think it's worth noting that the process has been very open, and stakeholders were given the opportunity to comment in writing at several stages on the development of the code. And the discussions on the code itself has included states, members of the Arbitral Commission, states, and many stakeholders. For example, I sit in the negotiation on behalf of the Institute for Transnational Arbitration, but there are also many universities and learned centers that participate thoroughly in the negotiation. So what's in the code? The draft code addresses the most cogent ethical issues that were identified by Working Group 3 delegates themselves, and more general by ISDS critics, and provided policymakers with numerous choices. So if you look at the progression of the code itself, the different drafts, you have bracketed tests so that the states, the negotiators could address the different options. And this bracketed test is really now very, very limited to very specific issues. And at the same time, there's also a commentary that's been prepared, which will be very helpful in understanding how to apply the code. And this commentary now includes a lot of the issues of kind of contention that were included in the different drafts. So what are the main features and definition? The code, we can think about the code as being divided in three sections. One, we have an introductory section that provide definitions and applicability. And then a second term that enumerates specific obligations of adjudicators, and finally, a short provision on implementation and enforcement of the code. Article 1 first provide then a series of definitions, which is quite interesting, and includes the paramount element of to whom the code applies and in what kind of cases. A big issue of contention: to whom does it apply and to what kind of cases? In terms of the definition as to whom the code applies, the draft of conduct specifies that adjudicators, so the code itself is called a draft for adjudicators, a code of conduct for adjudicators in ISDS. How do we define adjudicators? It means arbitrators and judges, so that if a permanent court will actually be established, the code will still apply. Although in the last negotiations, there was an agreement that it will have two codes, actually, one for arbitrators and one for judges. The provision also includes elements for those who are being considered for appointments, and also for assistance to the tribunal itself. So it defines candidates as a person who has been contacted regarding potential appointments as an arbitrator, and provides also a definition of assistant as a person working under direction and control of an adjudicator. Both issues are obviously very important. And also so in what situation does it apply? How do we consider ISDS? This was also another issue that was negotiated quite substantially, and Article 1 now includes the definition of the kinds of dispute as IID, international dispute. The international investment dispute means a dispute between an investor and a state or a regional economic integration organization, submitted for resolution pursuant to a treaty providing for the protection of investment or investors, legislation governing foreign investments, or an investment contract. This definition has changed quite a bit. Initially, this was in the initial draft, but then it changed to include only treaties, and now it includes contracts and domestic legislation again. Article 2 then also specifies the code that applies also to other proceeding. What happens also if there are other code of conduct that exist? As I mentioned, there are some code of conduct that exist in some BIT. So what happens then? Those take priority in application. There will be more on the code itself, on the application in the commentary. The core of the code is really Article 3. And Article 3 enunciates the fundamental duty of independence and impartiality of adjudicators, categorically stating in this first sentence that adjudicators shall be independent and impartial. An initial reference also included more, but negotiators have said this is enough. We know that we want arbitrators and adjudicators to be independent and impartial. And so this is in the first sentence. The second section of Article 3 enumerates particular examples of specifically prohibited behaviors. And they go from letter A to letter F, although the list is not exclusive. And much discussion has occurred on letter A that says that adjudicators shall not be influenced by loyalty to a disputing party, a non-disputing party, a non-disputing treaty party, or any of their legal representatives. This text will be maintained. There was a final agreement, but there will be a lengthy explanation of what loyalty means in the commentary. Indeed, all negotiating parties agreed that independence and impartiality are essential to the success and implementation of the code. And however, the issue that needed to be addressed was the exact definition of what we mean by independence and impartiality. So during discussion, two issues really ensued. One was how to concretize the abstract principle of independence and impartiality. And second, how to ensure that the fairness of the process, the assessment of the existence or lack of independence and impartiality will have to be taken into consideration. And the idea is to address it as from the point of view of a reasonable third party. In terms of the other articles, Article 5 includes a duty of diligence, Article 6 including issue of integrity and competence. So that, for example, adjudicator shall conduct investment IID proceeding competently and in accordance with high standards of integrity, fairness, and civility. Article 7 prohibits ex parte communication. Article 8 addresses confidentiality. And Article 9 includes and addresses fees and expenses that have to be agreed upon through the institution if the institution exists. So all these issues and discussions were productive and conclusive, and we are very close on all these issues to a final text. But if you listen to when I was talking about the different number of the articles, of course, I didn't mention them all because there's still some issues that are still pending and need to be addressed. And there are three issues really that have to be agreed upon that are still at the core of the next phase of the negotiation. Article 4 relates to multiple heading and how do we deal with multiple hats and how do we address that. Article 10 talks about disclosure obligations and what are the obligations vis-a-vis disclosure. And Article 11, how to be compliance with the code, how to comply with the code itself. So where do we stand on those three issues? As for the first one, I mentioned earlier that the Ancestral Commission Working Group 3 mandated specifically the working groups to look at the three main issues of issue conflict, repeat appointments, and double hatting. Both repeat appointments and issue conflict are addressed now as issue of disclosure and are not addressed directly. But the issue of double hatting is still something that is being addressed specifically and is regulated in Article 4, which is entitled Limit on Multiple Roles. It's not entitled double hatting or multiple hatting, but limit on multiple roles. And so from a codification perspective, double hatting is really a complex issue. Should it be prohibited completely? Which is what, for example, CETA has decided to to do, or but what would be the cost in that case? Some are concerned that a prohibition on double hatching would undermine diversity and the possibility of new entrants in the system. Alternatively, double hatching could be regulated exclusively in terms of the total number of cases in which an arbitrator can sit at one time, or by considering the time frame involved in the different proceedings. And this method is chosen, for example, by others. For example, the International Court of Justice regulates in that way how it includes a time limit. The working group considered all these kind of options. To whom should it apply? To what are the specific double hatching? Is it only counsel and arbitrator, or is it agent? Is it expert? So to whom does it apply, and how to regulate it? And the working group considered all these options. And during the last negotiation, it was recalled that there had been a wide range of views, both in support of a full and comprehensive prohibition of double hatching, as well as in support of imposing robust and extensive disclosure requirement only. Article 4 was drafted to reflect a compromise that was reached on several points. One, that while there was continued support for a compromise reached to limit double hatching during proceedings, views diverged on whether there should be a time period following the conclusion of the investment arbitration proceeding, during which an arbitrator would be limited from undertaking roles as legal representatives or party-appointed expert. Some, and this is what is included in the draft now, support a 3-year period, like a ban of 3 years. And what kind of proceedings? So is it only other investment proceedings, or is it all international proceedings related to states, interstate proceedings? And this also, of course, is another big issue. The article, there is still the different views that were expressed, and there is no agreement at the moment. But we talked about measures, double hatching and multiple hatching, for issues that involve measures, the same or related parties, or some provisions of the same treaty. And in paragraph 2 of Article 4, issues that are legal issues which are substantially so similar that accepting such a role would be in breach of the previous articles, and especially Article 3, independence and impartiality. How do we enforce a double hatching prohibition? The code now talks about a self-judgment by the arbitrator itself, by the arbitrator him or herself. This will be very important in the, we will have to see how the 5th draft of the code actually address this issue. But at the moment, there is an agreement to regulate it somehow without including a full prohibition, but to regulate it in terms of what are the cases and possibly introducing a time limit. Which brings us to the last 2 issues, disclosure and implementation. Article 10, which is another key provision together with Article 3, articulates disclosure obligation. This was only discussed once, and there's still a lot of work that has to be done on the extent of disclosure. And the code really adopts a enhanced disclosures as a regulatory tool. For example, as I mentioned before, both issue conflict and the number of cases are now regulated just as disclosure obligations. The draft code uses extensive and continuous disclosure obligations for adjudicators, an essential policy tool, and the basis also for its implementation strategy. Disclosure obligation exists at all times in the proceedings. They are continuous, and an adjudicator should err in favor of more disclosure when there is any doubt. Arbitrator and candidate should make also reasonable or best, there's still a choice between whether it's reasonable or best, efforts to become aware of possible conflicts. There are 8 paragraphs now in this article, which really shows how important this issue is. And some of the issues are what to disclose, what kind of cases, what kind of relationship, and also for how long. How long in the past do you need to disclose any kind of relationship? There was no time to finalize the discussion in the second reading, and so there is there are still some bracketed tests in Article 10. Article 10 now includes, similar to Article 3, initially a non-exhaustive general requirement disclosure. It also requires disclosing specific professional business and other significant relationship with the parties, counsel, present and past adjudicators or experts in the proceeding and other third parties, as well as direct or indirect financial interests. Paragraph 2 also requires arbitrators and candidates to disclose any financial, business, professional, or personal relationship in the past 5 years with any disputing party or any entity identified by a disputing party. So a lot of discussion, a lot of interesting questions here about what to disclose, how long, what kind of relationship, what issues, and how far back. So for my last point, compliance with the code. This is Article 11. And the code, of course, without a strong and effective implementation and enforcement mechanism, will be very difficult to implement, and really will be difficult. Will not be easily. It's difficult to make it work if there's no implementation mechanism. But yet it's very difficult to find a proper implementation mechanism because the code itself, as I mentioned at the very beginning, is going to be implemented by different institutions. And so how do you kind of square the circle, if you will? How do you do that? At the moment, discussions have been really quite embryonic. They're present a discussion, the Article 11 now talks about the fact that the adjudicators themselves have to comply with the applicable provision of the code, while issues of challenges will be regulated by their institutions itself. So that any disqualification and removal procedure or any sanctions and remedy will be continued to apply in the institutions themselves. So how do we want to address this issue? I think there's a lot of space for innovative thinking here. And there are examples that one may think about in terms of implementation. For example, with the World Bank and the Office and Suspensions and Debarment, which provide some possible food for thought, or maybe the creation of an ombudsman in some institution. So in sum, overall, the discussion of the code have been largely positive. There's been quite a lot of discussions and quite substantial agreements on a lot of issues. Delegates have agreed on the general direction and drafting of the code and have suggested linguistic changes on the draft to better address specific concerns. So most of the issues have been agreed upon, but there are still issues that have to be decided and have to be negotiated. As I said, the multiple heading concern is probably the most relevant and most important one, and the extent of disclosure, and then of course, implementation. So where do we go now? As I said, the publication of the 5th draft of the code is imminent. I actually checked this morning. It's not on this morning, but I understand it's really it's forthcoming. There are going to be more discussions. One in Vienna in January, and then in New York. The working group 3 has decided now to meet 3 times to discuss all of the ISDS reforms. The next one then in Vienna, in New York, and I think that probably the draft code will be presented for approval at the next session of the Commission in the summer, possibly a year later than expected, but still a very important development and quite fast in terms of the overall ISDS project. So I asked at the beginning, is it a low-hanging fruit in terms of ISDS reform? I think it is. I think we can still do it. And I think it's very much on track to agree and be decided upon in 2023. So thank you very much. And I'd be happy to take any questions, Ivan. Can I take questions or? Oh, I have a, am I supposed to give? Oh, I see you want to show the camera there. So
my question is regarding, you mentioned about the past disclosures of up to 5 years, as mentioned in Article 11, paragraph 2 of relationship of arbitrators with any other entities. Why do you think that there is a stringent measure that is being taken by the Arbitral Working Group 3 when the IBA conflict, guidelines on conflict of interest in the orange list describes only 3 years.
Mhm.
So why is the rationale of increasing from 3 years to 5 years in the fourth draft of the code?
Yeah, thank you. This is an excellent question. I think there's still debate on the extent, but I think there's a lot of. I think we have to think about it in the context of the ISDS reform in general. This is an international reform process and is targeted to investment arbitration, which is a very complex and sensitive issue because it always includes states and so, there's always a sovereign counterpart. So I think states themselves want to be as certain as possible that we agree on ethical standards that are kind of the highest possible level so that we avoid conflicts altogether. Recently, if you've seen, the numbers of challenges have increased, and I think we want to avoid that so that if there is a very extensive disclosure, we will avoid also challenges procedures. And this is, however, this is still, a draft test.
Hi, Chiara. Two quick questions. One technical and one aspirational. The technical one is, I think you mentioned that the code would apply to candidates who are approached by counsel. How would that work with double hatting and issue preclusion? Obviously, counsel can approach several people at that point and use it strategically. So I just was curious about how that would approach. It seems potentially problematic in my view. And then the second question is, why will this be different than the Mauritius Convention? There was a lot of interest in transparency, and Mauritius has now become a little bit of soft law and not hard law. And I know you want this to be hard law.
Yeah, thank you very much, Padre. These are both excellent questions. I'll take the second first, because I don't think so. When I was thinking about implementation, I think we have to think creatively about how to implement. And the Mauritius Convention is a treaty, and the issue of transparency. So how to implement it here? I think we can do it much more easily. And for example, I know that ICSID is thinking about including a version of the code in the disclosure appendix, like in the disclosure that the arbitrator has to fill in. So it can be much more easily applied, if you will. You don't have to have a treaty. You can have a treaty. You can have multiple ways to implement the code and enforce the code. But in terms of implementation, yes, you can go through a treaty, but you can do it also in a way that is more simple and included in the disclosure form of the arbitrator, which will guarantee that is applied much more thoroughly to many more institutions. But I agree with you that you have to. There's a lot of interest now, and will it bear fruit when we actually have when the code is approved? So this is why we have to think about how to implement it. As for the first question, I think it's a very interesting question. Also, there are limits in terms of. In Article 1, one of the definition is also ex parte communication. So it has to be very specific on what is allowed. And I think you're right that parties may be strategic in how they select arbitrators. But I don't think that at the moment, the fact that to apply the code, there are certain provisions that applies to candidates. And I think is to guarantee disclosure and to try and make it as transparent as possible. It has to be disclosed to the other party also. I don't know if I reply fully, but.
Well, just one more question, and so that people can see you. That will be the last one.
Thank you, Jose Antonio. Thank you, Chiara. One sort of academical question about the implement or the application of the code. There are certain, I'm not gonna say rules, but like recommendations for adjudicators to disclose some information that has been discussed for the last 2 years already. What's gonna happen? What do you think should happen, if you could give us an opinion or not, about the cases that have been going on during these 2 or 3 years of discussions? And an arbitrator did not disclose something that is in the code, but it's already known that is something that should be disclosed, that because the market considers that is a problematic thing that should be disclosed. So there's going to be a gap there that I don't know how it should be covered. So that was my question.
Yeah, it's really an excellent question. I think you're right that there are issues that many stakeholders think that should be disclosed, and there's a market for more disclosure, but there's much more reticence in disclosing by the adjudicators side. And the code will only be applied, obviously, in the future, but there's nothing to that the parties, of course, can themselves agree on maybe requiring more disclosure, but the code itself would only apply going forward. Thank you. Thank you very much.
Thank you, Chiara, for this truly informative and succinct and also newsworthy introductory speech. I think that you did a great service to the Washington community and to investment arbitration and international commercial arbitration, and in general to Washington Arbitration Week. I mean, I would like to thank you. It's not easy because the issue of the code of conduct is an ongoing debate. The 10 to 15% that is remaining is really litigious. From you could hear from the questions. With that, I think that we'll close this session, and let's give us 5 minutes for those that are online, are here. I apologize because I did not introduce myself, which I should have. My name is Jose Antonio Rivas, and together with Ian Laird, we embarked 3.5 years ago to create Washington Arbitration Week, which was simply a matter of necessity. We didn't have one, and the pandemic allowed us to create it. And with the support of many of whom I see here, we were able to put it together. As Chad said, according to our numbers, I think that it's at least in the U.S. is the most attended virtually and now hopefully in person arbitration week. The model is one where we focus on the substance. We focus on, and for those of you who have been involved, we focus on the question, and after focusing on the question, we start asking ourselves, who is the expert on this issue? By a very simple structural process. We do not choose speakers before we choose the actual topic. We do it the other way around. We go to the substance, and then we ask, who is the expert? And of course, the expert may be a professor from Bologna or a professor from Richmond University, but it may be also somebody who is in the other side of the world in Australia, and we try to bring them here. Of course, the good thing that we have in Washington, D.C. is that there may be experts on almost every issue of public international law. So this is a prime place for an arbitration week. There are no fees, both because our hosts are gracious enough not to include fees, and also because online people can attend just by signing in. And one additional feature which we are implementing this year is that everything that you see here is now recorded. One, and two, it has a specific automatic transcript to the recording, so that you will use, and researchers and students will use the transcripts as a tool of research. As you could see, we hope that speeches like this are looked online with the tool, because that's creation of knowledge, which we expect to move forward. And with that, I'll stop giving ourselves praises, and we'll have a 5-minute break. Thank you.